Hi lawyers and IP students from around the world. I want to present you a decision from the Court of Justice of the European Union of September 2020 on relative grounds with regard to trademarks. So it changed a bit my approach, I must say, what I was doing at the Boards of Appeal when I was there. Because there was a new element which I actually was not aware of, and the Court of Justice pointed into that direction. So it is, I think, worthwhile that you should know it, because it changes a bit the approach you may have in advising your client or in presenting whatever your briefs to EUIPO or the Court of Justice. It involves what you naturally know, which is Lionel Messi, a international football star from Barcelona previously, and now in Paris, TSG, Paris, and Paris Saint-Germain, I think, and he is the captain of the national football team of Argentina. Now, he is also, what you might not know, an active IP actor, so to say. He has, I read, some 130 trademarks on his name. So in 2011, August 2011, he applied for the trademark Messi. I will here give you the fact sheets. Here's the fact sheet where you find the trademark as such. So it is in a stylistic M with Messi on the downside. It is applied for goods in class 9, 25, 28. So emergency rescue apparatus and instruments, class 9. The headings of class 25 and 28, gymnastic and sporting articles. Well, I tell you this for exhaustion or for completeness, but it is in fact not really about the goods and services, the goods. Well, it went through and one published, and then an opposition came in based on two earlier marks, word marks, identical word marks, MASSI, right? So these word marks were protected, one in class 9 and 28, helmets for cyclists, protective clothing against accidents in class 9, clothing, shoes and headgear for sports in class 25, and 28, bicycle gloves, shoulder, elbow and knee protectors. Okay, so one of the marks was older than 5 years before the filing, so it went, you know this, to proof of use requirement. Now, I will not go much into this, just that you know, proof of use requirement, the owner of the earlier mark, in class 9 and 25, had to present some evidence, and it was accepted for helmets for cyclists and nothing else. The class 25 goods were not under proof of use. So in these conditions, the opposition division said or found that the goods are identical or similar, and the trademarks were, so to say, highly similar in the visual and in the oral sense, and they were conceptually similar, well, dissimilar, so to say, because MASSI had some meanings in, well, I spare you the countries in Bulgaria or whatever, and Messi would like Italian. Well, it's not really important, but they said, well, likelihood of confusion is there due to mainly the oral and visual similarities. Okay, so the Lionel Messi was not happy with that, and it went to the Boards of Appeal. The Boards of Appeal confirmed the opposition division decision, It found, though, that the goods in class 28 of the early mark, which was under proof of use, was also proven for bicycle gloves. So that makes, so to say, the case even stronger with regard to the goods, and the reasoning with regard to the marks, the trademarks, the signs were even were confirmed at the end. So Lionel Messi, still not content, went to the General Court, and then which overruled the decision of the opposition division and EUIPO and the owner of the earlier marks, which were aggrieved then by the General Court. They went to the Court of Justice all up, and we had a decision from the Court of Justice, as I told you, in September 2020. So what was the General Court's, so to say, finding, and what was new with regard to the EUIPO? That's I want to discuss you. With regard to the goods, well, they didn't found anything much different. They confirmed more or less what was the decision of EUIPO, of the Boards of Appeal. So the goods were either identical, class 25, or similar with regard to the others, and which has proven the use with regard to the earlier mark, right? So the goods and services, no, the goods only were similar. Now, with regard to the marks, they confirmed what is the settled case law with regard to figurative marks, so the Messi mark. We have the stylized M on top, and we have the Messi, the word Messi below. So this is the ornamental M, the stylistic M, as a, as a decorative character. What is dominant and well, perhaps dominant not, but what is at least more distinctive is not the ornamental element, but the word Messi. And MASSI, well, it's a word mark. What happens now with the oral and the visual comparison? Well, with regard to visual comparison, the stylistic M can be neglected. So we have Messi against MASSI. Oral, highly similar, I would say, depending on the country where you're in and the language you're using. And now the conceptual comparison, which is at the crux here, and where the General Court diverged from what was the assessment of the EUIPO, and I would say even what is the general approach of the EUIPO, which it has been taken in that case as well, and which was, so to say, a proven practice from the past. Well, EUIPO said, well, it was the Boards of Appeal, right? The Messi was a football player, but is not necessarily known by everybody, not in the whole European Union. Those part of the public which would recognize Messi, they would refer it to the football player, but others and the majority would not. So the General Court, and in agreement with the Messi arguments before the court, said that, well, it was notoriously known, that player was notoriously known. Lionel Messi is known all over. It was one of the most notorious football players from around the world. Is one of the best actual football players. The FIFA has, the merit of the FIFA which he has received, etc. So even though for people who don't know Messi, they have easily sources available in order to get to know him and his fame, his reputation, which precedes him. So, meaning that the General Court took up the argument that the reputation of the younger mark, in this case it is the younger mark, the reputation of that guy, of Messi, was of utmost importance for the conceptual comparison. So the people would be able, due to Messi referring as a concept of a football player, of a specific football player, that one playing with FC Barcelona by the time, was the one which had to do something with these articles, namely with sport articles, and therefore it was able for them to distinguish conceptually between the both marks. So even if they are aurally and visually similar, the conceptual difference between one and the other was sufficient to rule out any likelihood of confusion, and even with the identical goods. That was the finding of the General Court. You find it here on the screen. Now, with regard to the Court of Justice, where EUIPO has been gone, the Court of Justice, they found practically the same thing. They reinforced the argument of the General Court in reality. Now, what does that mean now as a judgment for your practice, for your approach with regard to EUIPO, with regard to some aspects how to advise your client on cases? So far, it was clear that a conceptual, clear distinction between two trademarks would be able to outrule what would be the likelihood of confusion, or what would be the similarity of the marks. But what we had not known so far was, or what we have not applied so far, was that the reputation of the person behind that mark was so important. So normally what we had said is that the reputation of the younger mark is nothing we should care about, because it is not even in existence, right? It is applied for, so it is not in existence. So I can remember the inclusive development theory in China, where we as the European Union, we talked against it and talked the Chinese out of that. And now here we are a bit in that situation, although it has been rather, the focus was, or the argument, main argument was, it was on the conceptual comparison of the two marks, where a likelihood of confusion can be ruled out. But on the practice, what does this mean for your practice? Do we now, if we have something, a trademark or a name, or what is on the trademark, even as a figurative one, is this a famous word? Is that a word that everybody should know? And or is that, do we need a famous person now? And what kind of evidence you need to present to EUIPO in order to profit, so to say, from this line of jurisprudence, of case law, what we know now with that Messi case? It is not very clear. Even there was another case, Neymar, also a footballer, but that was a bit different. So in that case, we had a bad faith. Neymar was a cancellation applicant against a registration, also Neymar, and he said against, there was a bad faith trademark. That was his main argument. And in fact, in that case, the applicant, the owner of the trademark, the registered trademark, he filed beforehand also trademark Iker Casillas, another football player, that this one of Real Madrid. So there was a bad faith issue, and this is different. So it cannot be referred to that one, although Neymar is also a kind of a famous football player. But in that case, it was on his name. Now, what we have here is now to say, how can we deal with that line of case law in the future? What is the kind of evidence we should present in order to be on the safe side, or can we rely on something which is notorious, as the General Court said here, and which was confirmed by the Court of Justice? Well, I think it is an interesting case. It is something which you may encounter only rarely, because you know the Messis are not all around. That is not the daily client you may face with, but still you may be in a situation where this can come up to. And if you have an issue, so a trademark, younger mark, which is a famous word, a very, very famous word, although it doesn't refer to a certain player, but this may give you an angle to play on the conceptual comparison, and to so to say, to restrain what would be likelihood of confusion. Thanks for this session tuning in.